Good morning, everyone. Thank you for taking your time and spending your an hour of your time this morning with us on this beautiful fall day in Texas. It's been a long time coming to have air like we have today. Let me just kind of go over a few housekeeping items to start with. Today, we're partnered with the Down Syndrome Association of Houston. So thank you for partnering with us today. If you are not familiar with the Down Syndrome Association of Houston, definitely check it out. They've got a lot of great things on their website that you can check out. So I'm Allison Scoberg here with Consolidated Planning Group. Consolidated Planning Group is a holistic special needs financial planning firm. We are domiciled here in Texas, and we serve clients all throughout the United States. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy. So people come to us because they want to know, how much do I need to fund a special needs trust? How do I preserve eligibility for state and federally funded programs? How do I make sure that I can retire and stay retired for 30 years and then provide another 20 to 30 years of funds for my loved one with a disability? And so we solve problems like that. And we often partner with law firms all across the country, and they don't work for us and we don't work for them. But today we're excited to be partnered with Leona Filis law firm, and she is going to be talking to us about the steps to consider when raising a child with special needs. And so we're excited to bring this topic today from a housekeeping perspective. We are in webinar mode, so in case you're wondering, we can't see you or hear you, but we do know you're there. The chat box is enabled today, which means that you can put your questions in the chat box as we're going through the presentation. I'll be monitoring that today for Leona, and we'll be getting to as many questions as we can throughout our time together. So today we're going from 11 to 12. If you're planning your day, we will be finished by 12. Today's webinar is also being recorded, so everybody that has registered will get a copy of the slides today, so you don't have to take notes on every single thing you hear. And you will also get a link to the recording. So one other thing that I want to mention that I think is important, because there often is a lot of confusion, Leona, on what you do and what we do. We get calls all the time of, hey, I need to set up a guardianship, or I need to set up a special needs trust. And you probably get calls on, how much do I need to fund the special needs trust? And can you help me with SSI? And so there is confusion on that. And the thing is when we have a loved one with a disability, it's important to assemble your team, and part of your team is on the financial side, part of the team is on the medical side, and then where Leona comes in is on the legal side. So while a special needs financial advisor doesn't do the legal documents, an estate planning attorney, a special needs attorney doesn't do the financial side as well. And so that's why you often need both. And I always just like to dispel that, because I think it's a lot sometimes, for sure. So Leona, tell us a little bit about you, and let's get started.
Oh, thank you. Thank you, Allison, so much for having me on. Thank you to Consolidated Planning Group and Down Syndrome Association of Houston. I'm Leona Filis. I'm an attorney, and I founded Filis Law Firm here in Houston, Texas. And we focus on helping families with children with special needs. I moved away from oil and gas a few years back and started focusing more on areas of law that affected families like mine, who have a child with special needs and still needs guidance and help to get the best outcome for their child. And what I've done is, over the years, I've just kind of collected different topics that are legal based. And it's just different things that can maybe help a parent guide them to the right next step to take whenever they're on their journey with their child, trying to go forward to the best outcome for them. So that's what I kind of have going on. I just, have been fortunate enough to be surrounded by family and friends who have helped me kind of figure out what is important to families and help present to these families different options. So you can go ahead and go on to the next slide.
I'm having a little bit, the slides are not forwarding. Let me try something else. There we go. And the disclaimer that you've got to do.
Yes, we're here for educational purposes. We're not creating an attorney-client relationship. And I have my contact information here at the top of this slide. We do offer free 30-minute initial consultations. So if a topic hasn't been completely addressed that we've covered today, go ahead and give our office a call and schedule a free consultation. So just quickly, we have about 8 things that we like to go over with families and friends whenever we're talking to them about their child that has special needs. From the first thing that we always ask, which is, are your children on the interest list for Medicaid waiver programs, all the way down to what kind of things you need to be aware of as a parent when your child with a disability is transitioning into adulthood. So we try to go ahead and we're going to cover all these topics today. So after your child is born and you have a diagnosis, the first thing immediately to do is look at your state's Medicaid waiver programs. There are in Texas about half a dozen programs. And what you'll want to do is you'll want to sign your child up on the interest list, the waiting list. And this is you're able to do this at the state level. In Texas, we have about half a dozen programs. Half of those are administered at the state level. The other half are administered at the local level. Next slide. So here's a list of these options that you have for services for your child. And you would want to go ahead and sign your child up for all of the applicable programs. A couple of them you may not have, if your child's already past the age of majority, then medically dependent children's program would not be applicable. If your child is not deaf, blind with multiple disabilities, then don't get on those waiting lists. But everything else, go ahead and put your child's name on those waiting lists. So at the state level, we have what used to be administered by DADS, Department of Aging and Disability Services, is now headed by Health and Human Services Commission. And one of the big programs that a lot of families look forward to receiving benefits from is called CLASS. For your child to qualify, their disability must have manifested before age 22. And with CLASS and other waiver programs, you can only be on one program and receiving benefits from one program at a time. So what you may have, hopefully, is a letter notifying you that your child has come off of the waiting list, the interest list for a certain program. And you'll have an interview, and hopefully your child will start receiving benefits. Once your child comes off of the next program's interest list, and that's when you'll try to decide which program benefits your child best, and then choose that program. With this one, with CLASS, which is probably the best program, I would say, when you have a child on the autism spectrum. One of the great things about this waiver program is that even though you hear the word Medicaid in the name, Medicaid waiver programs, you don't have the income eligibility factor that you typically do with Medicaid itself. So with CLASS and most of the other waiver programs, the income of the household is not considered. You would need to make sure that your child, who would be the beneficiary of the benefits from these programs, doesn't have a significant income that would place them out of eligibility, and that they don't have more than $2,000 of assets, non-exempt assets. Next slide. So CLASS, Community Living Assistance Support and Services. This program includes services such as physical therapy and occupational therapy, but that's only to supplement therapy for your child after they have exhausted receiving those particular types of therapies from the public education system. So if they're in high school, they have the option of receiving speech and physical therapy and occupational therapy. But once they age out of those benefits from the school system, then CLASS will pick up those therapies. Respite care is very important. Getting your child dental work, and then also dental sedation. A lot of our kids on the spectrum or with other conditions cannot sit still and allow for a dentist to do dental work. And so dental sedation is necessary, and CLASS would pay for that. Next slide. So the reason why the CLASS waiver program is highly recommended for families with children that are on the spectrum is because of these specialized therapies that are only offered by the CLASS Medicaid waiver program. And aquatic therapy is one of the specialized therapies, massage therapy. A lot of our kids on the spectrum also have high anxiety. So the massage therapy, the music therapy, that all comes with CLASS if your child is eligible. So that is just one of the many waiver programs that offer benefits that will help your child for free. Go ahead and go to the next slide. The issue is that there is a long waiting list. And this is why this step is the first step that I and my staff take whenever we are meeting a family for the first time that has a child with a disability. We want the parent to make sure that their children are on the Medicaid waiver program interest list. For example, this particular chart is from Health and Human Services website. And listed across the top are the different waiver programs. And as you can see that there are many people, even with that first column for CLASS, that wait 15, 16 years before they come off of the waiting list and become eligible for benefits. Go ahead and go to the next slide. All right, so for some of our kids would qualify for a waiver program called Home and Community-Based Services. And this particular waiver program is very beneficial for kids that may have intellectual and developmental disability included in their diagnosis. Go ahead and go to the next slide. So with the IDD, we have some of the kids, if their IQ function level is below 76, or I believe Allison had mentioned previously, if there is a related condition that also is assigned to that child, the IQ level can be higher.
So it's basically 70 and below. Sometimes they say 69 and below, 70 and below for HCS, or 75 and below if they have multiple diagnoses.
Okay.
And so most of the waivers, not all, the CLASS waiver does not have that IQ of 70 and below. Most of the waivers do have a requirement of intellectual disability, which is that number. The other waiver that doesn't have that IQ, the community first choice, and also the YES waiver does not have that IQ number.
All right. So different programs have different requirements, and they all offer different services. So with HCS, which would be really beneficial for the kids with the Down Syndrome Association of Houston. The HCS waiver will allow for the payment of a day hab or even respite care, nursing services, and even paying for residential assistance like at group homes. So with some of our kids that will be affected for the rest of their lives and not be able to live on their own, the HCS waiver is very helpful because of that component where they will pay for a group home and the day hab for your child's life. Go ahead and go next. Okay, so here is with all of that information, with all the information about the different waivers, it just is like a 10-minute phone call. So if you do run across someone that you know that has a child with special needs, or if you yourself have a child with special needs and have not signed them up yet, please go ahead and take down these numbers. If you are in Texas, that top number is the first number that you'll call, and that again is Health and Human Services. And then you will get registered, or your child will get registered for about 3 or 4 programs. Then you will be given the phone number for the local authority to sign up for maybe 3 or 4 other programs. So if you're in Harris Center, if you're in Harris County, you would call the Harris Center. And the information that they're going to request from you when you make this 10-minute phone call is your child's social security number, their date of birth, their name, and then also for the parent, these agents do want to make sure that you are aware of the length of the wait. And as we said previously, with some of these, it's over a dozen years waiting for services.
We actually had an HCS webinar this past week with somebody from them, and they're now saying that the HCS waiting list is as much as 20 years, is what they said this week, which is shocking. I've been hearing 17 years for a while, but 20 came out this week. And so, I mean, but that's all the more reason to get it started. And, you know, we talk about these waivers, and a lot of times, you know, people they hear through the community that we need to get on these lists, but what does this actually even do? If you're not getting a waiver, what is the point of the waiver? And really the point of these waivers is to keep your loved one in home and community-based services. That is the premise of most of these waivers. It's designed to waive off some of the cost of care for caring for an individual with a disability so that they can remain in home and community-based services. And the waivers provide, each of the waivers provide different things. One place that you can take a good peek at some of these waivers, of course, is the Health and Human Services website in Texas, but that website's a little overwhelming. Navigate Life Texas is a nice website where it kind of gives a little blurb on each one of these waivers and what they cover. We have somebody in the chat box that said, my son has an intellectual disability, cerebral palsy, and autism. He is getting the HCS services at the moment, but he has autism as well, and he needs to get the therapies, like both therapy, massage therapy. Is there any way that we can get them under HCS? And I think that's the kind of the point that you are making is, some people we hear often say, well, HCS is the best waiver out there. This is the best one. If you come up on the HCS list, you should take it. And that's not always the right answer, because sometimes that class waiver was a better waiver for you because it provided some of those therapies that the HCS waiver won't. There are a number of therapies that the HCS waiver won't pay for, but it could pay for more attendant hours or respite hours and things like that. The budget, as a general rule, on the HCS waiver is far greater than the budget of the class budget. So depending on the level of need of the individual, the HCS waiver could provide way more than the class waiver, but they're not going to cover those types of therapies. So we do suggest, and I know, Leona, you said this, if you're getting the class waiver and you come up on that HCS list, work with a professional, figure it out, put it pen to paper, dollars and cents. What does this mean to you? Should you switch or should you not switch? Don't just listen around the water cooler of other special moms that say that the HCS waiver is the best. It might be the best for their kid, but it absolutely may not be the best for yours.
Right. And don't forget that Medicaid comes with these programs. So it's you might want to see if some of these therapies would be covered under Medicaid. And then we'll get to it a little bit later. But if your child receives Medicaid, but you also cover your child on your employer provided health insurance, there's something that will motivate you to keep your child on your private insurance. So that private insurance may cover some of these specialized therapies. I understand that in Texas, Medicaid does now pay for some ABA therapy. It's just trying to find a provider that actually would take Medicaid. So we can move on to the next slide.
Well, Leona, you bring up a good point, and we do talk about this a lot because a lot of families will come in and they'll say, well, why should I have Medicaid and my child is covered for Medicaid by Medicaid and Medicare? Should I keep my private health insurance? And my answer is always yes. If you can keep the private health insurance on your child, and just so you know, if your child's disability started in childhood, there is a form that your HR departments on these group health plans that will allow you to keep your adult child on your group benefits past the law of age 26. They don't advertise it. Oftentimes when you call HR, they'll transfer you 12 times because they don't even know what you're talking about. But it is there. There is a form that you can fill out, and you can keep these kids on the benefit. So why are you telling me to spend more money and keep group benefits? Is the freedom of choice. Our kids have disabilities. They see specialists. They probably see more specialists than they do their primary care physician. You want the freedom of choice to take your child to the good doctors, to the doctors that you've had established relationships with. Many doctors do not take Medicaid. So if you're simply relying on Medicaid, you are going to have to change providers, and you might not be happy with that outcome. Now, the beauty of Medicaid is all the hospitals take Medicaid. So if you have a child that has frequent hospitalizations and things like that, that is good. The beauty of Medicaid is Medicaid often swoons in and pays your deductible. Those are things that can happen. But the why is the freedom of choice. Medicaid is state specific. So if your child has some major thing wrong and the only hospital in America that handles it is in Maryland, Medicaid isn't covering that. So your private health insurance will. So those are just some of the examples of the why behind it. But I am super advocate of keeping your health insurance if you can help it.
Definitely. And then I have a question about Bexar County. When you call that main number for HHS and go through the questions with HHS about adding your child to the interest list at the state level, they'll provide you with the contact information that is specific for your county.
Also, there's a website. So all of these places where you get on the waiver for HCS, Texas Home Living, Community First Choice, those are your local intellectual disability authorities, which you were talking, also called a LIDA. So if you type in local intellectual disability authorities, Bexar County, you're going to find out who your LIDA is, and that is exactly where you get on those lists. But I just want to, and we do have a whole separate webinar on waivers and a link on where you can get, it is a separate phone number. So a lot of times people call their LIDA, Leona, and they think that they're on all the waiver interest lists, but they didn't call class and MDCP, and that is a separate phone number. So it's really, really important to know that.
Definitely. So I was just letting you know that if you have all these people on these different interest lists, we need to ask our legislators to increase the slots so that we can have more people other than 381 in 1 year added to the class program. Since there's over 300,000 on these various waiting lists as of, I think it was June of this year. So let's try to try to be more informed and go ahead and ask for more resources for our kids. To the next slide. Okay, so with the waiver programs becomes Medicaid. And as we were talking about, we wanted to make sure that we have the kids covered on the employer provided health insurance if it's available, and then also have them on Medicaid. And the reason why we've already gone over, but one of the other benefits that the state of Texas offers if you qualify is the Get HIP program, and it's HIPP. And what that does, it's the health insurance premium reimbursement program. So if the state of Texas, who pays for Medicaid, would save money by you keeping your child on your employer provided insurance, and then just paying you your premium amount every month, they'll go ahead and do that if you qualify. So you would go on to the HIP program website that's hosted by HHS and see if your employer provided health insurance qualifies for you receiving a reimbursement check every month. It's not for just the amount of the insurance premium that covers your child. It's for the entire amount of the premium that comes out of your paycheck every month. So that's another benefit for utilizing, getting the waiver programs, getting services through the waiver programs, receiving Medicaid for your child, and then getting the reimbursement check every month from the Get HIP program.
I used to not recommend this because it was such a headache to get this approved. But in the last several months, people have been saying and reporting that they really had no issue in applying for this, and that the process went smoothly. So if you've gone through this before and you didn't get it and trying to appeal, try again. So it was bumpy before, but definitely an improvement. We got a couple of questions. So a person says, we're talking about 20 years to receive services. My daughter's 16. Is it too late to be added to the waiver program? It is never too late. It is never too late. The sooner you get it done, the better. And there are such things as crisis diversion slots. So, which basically moves you from this long waiting list to right now. So if the individual is a threat to themselves or others, if they're at risk of being placed outside the home, if the family can no longer provide caregiving services they once did because of an illness, because of an accident, because of a death, those are examples of some of the crises. There's many, but that could move you ahead in that example. Another person said, I currently have my son on MDCP and recently added him to my insurance with my employer. I assume that my insurance would be the primary and Medicaid would be the secondary. Would it interfere with respite getting paid? It shouldn't. Would Medicaid benefits be interfered? Your primary insurance is going to be your health insurance. Medicare, think of Medicaid, a federally funded program, is always going to be the last payer, the payer of last resort. So if a person has Medicaid and Medicare, depending on the size of the employer, it's usually your group insurance will be primary, Medicare would be secondary, and then Medicaid would pay third. If your employer is super small, Medicare may pay first, your primary insurance second, and then Medicaid third. And so it says, if your child is already aged out of your employer-sponsored insurance, is there a way to have them covered again? Turned 26 in March, didn't know there was an option to stay on. Yes, and you should contact your HR and don't take no for an answer and keep being moved up the flagpole if you need to get a supervisor or whatever. There are forms and there is availability to do that.
Nice, good. Next thing that we'll talk about is also tied to the waiver program. It's called getting a DID. A DID is a determination of intellectual disability. So if you go to the next slide, you'll see that some of the recommendations is that we go ahead and go to that LIDA, that local authority for your county, and request that they test your child's IQ. And with that IQ determination, your child may become eligible for more programs with the Medicaid waiver programs or other local programs. So it's just a good idea to go ahead and get the child's IQ tested if they're age appropriate. So qualifying for these Medicaid waiver programs, your child is not supposed to have assets that exceed the value of $2,000. So what we do is we want to work with financial planners, like Consolidated Planning Group, and make sure that in the future, when your child is going to receive life insurance proceeds, that they personally do not receive those assets, the cash assets, that it goes into what's called a special needs trust. You can go to the next slide. Okay, so for SSI, you cannot, for the child to qualify for SSI, and we're thinking about, when the child turns 18 and they're transitioning into adulthood, even if they've had SSI and Medicaid in the past, you'll have to reapply for your child when they become an adult. But their assets and their income is what will determine their eligibility along with their disability. And you want to be able to plan smart and provide for your child for the rest of their life. And so what you would do is contact an attorney who would prepare what's called a special needs trust or a supplemental needs trust, so that in your estate planning, if you have a spouse and 3 kids and you say that your spouse gets all the life insurance proceeds, and then alternatively, if your spouse has predeceased you, you want the 3 children to receive equally the proceeds from your life insurance. The issue is that cash would be considered a non-exempt asset by Social Security Administration, who would then have your child disqualified for their government benefits that you have worked so hard to get. So instead of directly pointing to your child who has a disability as a beneficiary, you would have a special needs trust created, and that will be as if it's its own entity. It has its own taxpayer ID number, and it would serve as the recipient of the child's assets. So that is why we ask parents to consider talking to an attorney when they are doing their estate planning or their financial planning, so that they can make sure that the benefits that they want their child to receive lifelong are not terminated because they have now put assets in their children's name, or they will potentially have assets in their name because of financial planning.
So 2 things I would like you to cover. Tell us the difference, a little bit of the difference on the first party and the third party trust, because I know that if you have child support post age 18, that you really need that to go to a first party trust. And then the other thing that comes to mind that is a big oops that we see in our practice is where a parent might be having a pension, a monthly pension coming in, and then they left their special needs child the beneficiary of the monthly pension, as opposed to that monthly pension amount going to a first party trust. So can you tell us the difference between those 2 trusts? Because sometimes I think there's some confusion.
Sure. There's a couple of different types of trust. There's a pooled trust, there's a first party supplemental needs trust, and then a third party supplemental needs trust. So the third party supplemental needs trust we just went over, that is what you use to put money, that the source of that money is from a third party. And that would be when you have a will as a parent, and you type out your will and you make sure that you have your children listed to receive their inheritance for the benefit of your child with special needs, the recipient of their inheritance would be a third-party trust. And Social Security Administration will not be able to count the assets that are in that child's third-party trust against them. So it is a safe place to have assets for your child with special needs so that they do not get disqualified for government benefits. A first-party trust is also sometimes called a self-settled trust. And so the source of the funds that fund the source of the assets that fund the first-party trust is typically from the person or directly benefiting that person. And so one of the big examples of what you would use a first party trust for is like what Allison said, child support. Social Security Administration will deem child support paid for the benefit of an adult disabled child against the adult disabled child, not against the parent who's receiving the child support. And so what we do now in divorce decrees or with modifications, whenever the child is getting closer to the age of 18, we try to have it where, one, the court order establishes or it orders the establishment of the first party trust. And then two, we have the payments of the child support made directly to the trustee. The trustee is typically going to be the parent who is receiving the child support. And this way, we are able to keep the income calculation against the child with special needs to zero. And as far as what the Social Security Administration deems qualifies as income. So again, the eligibility for SSI is twofold after you meet the disability requirement: income and assets. Assets cannot exceed $2,000. And then the income, there's a calculation that you can do to make sure that any income, which is deducted from the monthly benefit of SSI, which right now it's $914 a month, does not drop down that monthly benefit to less than $1, less than zero. Once you wipe away that monthly benefit of $914 because you are deducting from it the child support, you will then disqualify. If it gets down to $0 or in the negative, you have now made it where your child will be disqualified from receiving SSI and Medicaid.
They just last week they announced the new numbers for 2024, and it's going to be $943 a month. So it's going from $914 to $943 a month for SSI. And then the other thing that I wanted to mention, that a question that comes up a lot is why can't I just leave assets to the ABLE account? Why can't I just redirect child support to an ABLE account? And the answer is no. No matter what you've heard around the water cooler, it is not true. You cannot leave life insurance proceeds directly to an ABLE account. You cannot leave pension assets directly to an ABLE account. And we'll talk more about it, but an ABLE account is another place. So it's a special needs trust and ABLE account. Those won't be counted against you. You would have an unlimited amount of money in a special needs trust, but there is a limited amount of money that you can have in an ABLE account. If you have $1 over 1 penny, really over $100,000, then you would disqualify from Medicaid and SSI as well.
Yeah.
Go ahead.
Everything over 100,000 would count as that asset, that $2,000. So then it'd be anything over $2,000 after you get past the 100,000. But it's also a bank account. It's not the recipient of assets.
Right.
a special needs trust is its own entity. It has its own taxpayer ID number. A lot of people say, I want to have a special needs trust fund for my child. Well, first you create the special needs trust, then you could create bank accounts or whatever to put the assets into. But the 529A is just a simple, it's a special type of savings bank account. And so even if some people have, let's say their child has a little part-time job and they want to deposit the child's paycheck into the ABLE account, that's fine. That will protect the asset, which is the cash, from the check, but there's still the calculation of the income. So
yes, and let's talk about that, because there is no such thing. I get this question a lot. There is no such thing as a direct deposit of your check to an ABLE account. So you would get your check and it would be deposited into the individual's bank account, and then you can certainly move it over to an ABLE account, but you can't do direct deposit from your employer directly to the ABLE account. And sometimes people think that they can do that, and then that money wouldn't be counted. It would still be counted. We've got a lot of activity in the chat box. Somebody said you have to get a lawyer. So yes, we are not fans of do-it-yourself legal work. When it comes to a special needs trust, you absolutely need a lawyer. And I would further say, get one that is nuanced and special needs, that's what they do, not somebody that dabbles in it and says, yes, I could create you a special needs trust. It doesn't mean that they're good at it or that they know what they're doing. We've seen a lot of special needs trusts that have created that were just wrong, that they're not right. So that it is important to really work with a specialist like Leona in that regard. Another person, I think you answered this question, are these trust accounts open at a bank after they've been created? So once an attorney has created your trust, then you're going to have that tax ID. That tax ID certification of trust you take to the bank, and you can open up a special needs trust bank account. I personally have had success at Wells Fargo and Bank of America, and not so much at some of the others. So, and the thing is, you have to put your patience hat on. These bankers, the banking industry is struggling to hire and keep people too. And they don't have people walking in and opening up trust accounts every day. And so it's clunky. They got to get people on the 800 number. So put your patience hat on, is what I would tell you. Someone says, what's the difference between a trust account and the ABLE? And that's a whole webinar in itself. But what I will tell you, so we do have webinars completely about the special needs trust and the types, and they all live on the Consolidated Planning Group YouTube channel. We also have a complete webinars on the ABLE account. But one big aha I want to give you to take away, the big difference of an ABLE account and a special needs trust is an ABLE account can pay for food and shelter without a 1/3 reduction to SSI. So a special needs trust can absolutely pay for food and shelter. But if you're getting SSI, there is a 1/3 reduction to SSI. And so also with an ABLE account, if it can be construed as achieving a better life for an individual with a disability, you can pay for it out of an ABLE account. The money grows tax-free. It's tax-free distributions, which is nice. It's almost like a Roth, you know, and it won't be counted against you. So there's a lot of reasons to have both. One person said, my daughter was denied due to the amount of the child support. So that tells me and Leona that you need a court order directing your child support to a first-party special needs trust. You need to set up a first-party special needs trust, and you need a court order directing that child support to the first-party special needs trust. And then you need to reapply, and they won't count that against the child. So that is the thing. It doesn't matter so much because a lot of our kids don't qualify for SSI prior to turning 18. And in the state of Texas, there is a lot of times where people continue to get child support post age 18 for an individual with a disability. And that's that magic age that we're talking about. If you yourself are receiving child support and that's going to continue post age 18 for your loved one with a disability, then the time is now. If they're 16, whatever age they are, you need to start having those conversations with a legal practice to get that money moved over to a first party special needs trust.
And one quick thing, you may have opened up a 529 bank account for your child, or maybe a relative has, which is the college savings plan. ABLE accounts are also called 529A. And what happens is that there's, like you can see on the screen, a lot of other types of expenses that can be paid for out of a 529A account. It includes education too, but it has all these other quality of life expenses. And so if you do have a 529 savings account for your child, go ahead and talk to your banker about moving those funds out of the 529 into a 529A. Social Security Administration, when they're determining whether or not your child is eligible for government benefits, if it's for SSI and Medicaid, they will count, Social Security will count 529 assets as assets, as opposed to 529A or ABLE account. The first $100,000 in the 529A bank account is not considered by Social Security when they're determining eligibility for benefits.
Now, on the 529C, now we help people with this all the time of converting. So she's speaking of 529C for college. You can convert up to $17,000 a year. It's subject to whatever the annual gift tax exclusion is. You can convert $17,000 a year from a 529C to a 529A. The owner in a 529C is the parent or the donor, the grandparent. And as long as the funds in the 529C are never paid out directly to the kids, so if the kid goes to college and they're paid out to the college, it won't be counted against them. And as long as the child is over 18, if that 529C, the owner is the parent, it will not be counted against them. But they cannot receive funds directly from a 529C. And so one thing is converting it, but you can only convert $17,000 a year. You can't convert all of it at once. The other thing is if you have other children, another way to fix this is you can change the beneficiary on that 529C to another child that may be using that money. But a lot of people don't want to do that, right? Because they want this money for the other child. But there are a lot of options that you can do with that. My slides went crazy on me.
Oh, well, that's the 529A, so that's fine. We can go ahead and keep on going. Those are, again, another list of the qualified expenses for what you can spend 529A expense assets on. So one thing that I talk to people about, and I don't sell life insurance or disability insurance, but one of the things I want parents to consider is making sure that they have sufficient life insurance on themselves and disability insurance for both of them. So in the event that you have, and you can go to the next slide. Yes, you have, let's say it's two parents and one child with special needs. And so we have one parent is the breadwinner parent and one parent is the caregiver parent. Both parents need to have life insurance, and both parents should have disability insurance. Even the parent that works in the home with the child and doesn't have an employer, go ahead and get the disability and life insurance policies. I just want parents to understand, if one of you has a problem where you become disabled or die, then we need to make sure that we have insurance policies in place to be able to supplement the payments for all the expenses for the needs of that child. And so if the caregiver parent passes away or becomes disabled, in some cases, that caregiver parent you'll need a team of people to replace what that one caregiver parent does on a day-to-day basis. So please don't shortchange the caregiver parent. Make sure that both parents have the insurance.
One of the things that we like to talk about is that life insurance passes tax-free to heirs. So for people that are going to have, the estate tax, max is going down unless they change it, and we don't know. It's anybody's guess on what's going to happen. So a lot of people may have estate tax issues. Other people have other kids. We want to keep your assets nimble in retirement. If you're going to spend 25 or 35 years in retirement, we want you to be able to have access to your assets while you are alive, and whatever's left can go to the special needs trust. And then there's life insurance that can fund the special needs trust. And I also like to think of a life insurance. So even if we're working with a family that's super affluent, we still recommend life insurance, just for basically an umbrella over your overall financial plan of what if the markets go haywire. The markets have been very volatile. What if they go haywire? What if something happens? What if somebody didn't work as long as they had planned because illness crept up, or an early death, or something like that? So those are all really, really important reasons. But the fact that life insurance passes tax-free is a huge thing.
So talking about that, with parents, we highly recommend having a will, power of attorney, and then medical power of attorney, also a physician's directive, HIPAA authorization or HIPAA release. In some cases, you may want to have a revocable living trust, but then also most definitely you'll need a third party supplemental needs trust. So going forward with these slides, if you have just a general will and you've gone to a very reputable attorney who has written wills and done estate planning for decades, they may not understand the ramifications for a child with special needs receiving inheritance. If the child receives inheritance, that inheritance would be counted as an asset. And if that child is on government benefits or will qualify for government benefits that are based on income and assets for eligibility, you have now, by leaving that child in your will to directly inherit, you have now disqualified that child from lifelong government benefits. And so what we have parents do is make sure that when they are taking that step and getting estate planning done by an attorney, that in the wills, when you have a child with a disability listed as a recipient of inheritance, that it's to be paid to a third-party supplemental needs trust. Some wills I have seen where they create the special needs trust in the will upon need. I do not recommend that at all. My recommendation is to have a standalone document, which is the child's third-party supplemental needs trust, where you, the parents, are the grantors. You, the parents, are the initial trustees, and your child with special needs is the beneficiary. You get the taxpayer ID number, and you can let that trust sit empty. But you point to that trust in your wills. You point to that trust in your financial planning documents. So Allison will tell you there are designation of beneficiary forms. And for your child with special needs, it doesn't need to say that child's name. It needs to say the name of that third-party supplemental needs trust.
I feel like I beat that horse to death talking about that, but I want to bring it up again. So what a lot of people do is on their beneficiaries, life insurance, pensions, just all the stuff that you can name a beneficiary. If I die, then it's easy. My spouse will be the beneficiary. And if I die and my spouse is already dead and gone, then that's easy. I'll just divide it equally amongst my children. And it is a problem if your child has a disability. And I find it a problem to name children outright if they're minors as well. If you name a minor child without a disability as a beneficiary and you die prior to them turning 18, that money sits in trust until they turn 18. And when they turn 18, they give it all to them, which is a horrible idea. I know your kids are geniuses just like mine, but it is a horrible idea for them to get that kind of money. And then the other reason clearly is that we don't want to name the child with a disability outright by their name. And how this looks is it's the third-party special needs trust or the supplemental needs trust for John Smith, as opposed to naming John Smith. That's the change that you can make. So the one thing I just want to mention to you guys is, so if you're taking notes, check your beneficiaries. Check your beneficiaries on everything: old pensions, 401ks, 403bs, life insurance with your employer, outside of your employer. Those are all places that you should check it. And the good news is you can check it, and they will offer you a change of beneficiary form for free. You do not need to hire me or Leona to do this. You can call your HR department for your group benefits and things like that, and check these things. But it's really, really important. And again, don't forget those old pension plans from 20 years ago. Don't forget those, because a lot of people do, and I've really seen those old pension plans come up and be an issue. So we're going to kind of speed up because we're just about out of time. We got about 5 minutes left, and so I'll take your guidance on the slides. So let me know.
All right, and just for one thing in the chat, it's one third-party trust or first-party trust per person, so you can't have a family supplemental needs trust. It is one person. So if you have 2 children or more that have disabilities, they would each need their own special needs trust. Now,
and then one other thing I want to mention, like in a divorce situation. So if there's a divorce situation and dad wants to have a third-party special needs trust for little Johnny, and mom wants to have a third-party special needs trust for little Johnny, there could be 2 special needs trusts for little Johnny and controlled by the various people. But the family trust, and this is one thing that we see a lot, Leona, is where somebody has created a family trust and they think it's a special needs trust, and it's absolutely not. That's a big issue. I know you see that all the time.
I do, unfortunately. And so in those cases, hopefully you can have a type of amendment to the existing family trust so that that the named beneficiary who has a disability, it gets changed to their special needs trust. So always try to get a third-party special needs trust as a standalone document that you point to in all of your estate planning. And if you don't have estate planning, then in Texas, and when you pass away, the laws of intestacy take over. And so you do not get to choose who gets your inheritance, who gets the items out of your estate. And unfortunately, if you pass away without a will, your child, not their trust, could be the recipient of the inheritance. And so you may, by default, by not having a will, then have your child disqualified for government benefits. And so there's a couple of things that your attorney will go over for you about what needs to be in your last will and testament. But you do have to have, at the very least, the testator, the person that is signing the will, needs to have the mental capacity at the time that they're signing it.
And one just little call to action here. Look at yourself. What do you have? Do you have a will? If you don't, you're not alone. A lot of people do not have a will, or they have a will that is grossly outdated that they did 10, 15, 20 years ago. They even have more kids since that will was done. It's time to review. If you have a loved one with a disability, I strongly suggest getting a will. It doesn't have to cost you $1 million to do it. B, if you already have one and you're not sure if it's right or not, get it looked at by a professional who specifically works, with families with special needs. Get it reviewed. There are ways to amend it, and update it. You may need a new one, but don't let it. If you're taking notes, check that out. And some people put this on the thing because they're busy, and then don't wait. Don't wait until something happens. Somebody's incapacitated, and it just didn't get done. Also, if you work for a large company, some large companies do have legal services where they either discount or you could get a free will PIP authorization, some of these documents, they do have some of those. And we are happy if you have a list to look at it. And you can ask them specifically, are there any special needs attorneys on the list? And we're happy to tell you anybody that we know is great if you have a list for something like that.
All right, go ahead and go to the next slide. So we do encourage parents to be their children's advocates. And then if the child is at a point where they have the capacity to do so, let them advocate on their own as well. And there is a lot of information online and in parent groups about the different laws that protect your child's education rights, which would include special education laws and in some cases, Section 504. But one of the main things is that if you know someone who has a young child with a disability, make sure that they understand that they can get services from the school district early on.
We did have a question in the chat box. When do you need a revocable living trust? And that may be a whole other conversation, but is there a why behind a revocable living trust?
So that would not include your child with special needs. Some people choose to put their assets in a trust as opposed to having all of their assets pass at the time of probate whenever they die. Or there's different preferences and pros and cons as to why to have a revocable living trust. But if your main asset is your house, be careful with placing your house into a trust. If you still have a mortgage on that house, then you could be triggering something called an acceleration clause when you deed the house out of your name and into your trust name. Go ahead and advance. And the last thing is going to be, we do encourage parents to request from the school district to put cameras in the classrooms that are the special ed classrooms where it is just self-sufficient and the kids are in that one classroom most or all of the day. They have their own bathroom in the classroom. Those types of classrooms can have cameras. So in the event your child who may not be verbal comes home with bruises or is starting to act differently when they get home from school, you may want the footage captured by the cameras to be reviewed to see if maybe somehow your child got hurt. And so we encourage you to exercise your right and have cameras in the classroom. And now once your child does get close to the age 18, if it's been recommended at your ARD meetings for your child that you get guardianship, you can approach an attorney who has a certification to be able to file guardianships. And this application to start the process for guardianship with a court can start as early as 6 months before your child's 18th birthday. But do you need to have a guardianship, or can you get by with a lesser restrictive alternative, such as using a power of attorney and medical power of attorney? Well, the way that I find out if a power of attorney is maybe a better option than a guardianship is by taking something called a physician's certificate of medical examination to your child's doctor. The doctor will perform a special type of examination in the clinic and fill out this physician's certificate of medical examination, and that will provide the medical evidence for a guardianship and let us know as attorneys if we should pursue filing a guardianship, or if maybe a power of attorney supportive decision-making agreement, if that is recommended by the physician.
So we've talked about a lot of heavy topics today: first party, third party, special needs trust, waivers, SSI, Medicaid. There's so much. And we do have webinars on every single one of these topics where we really take a deeper dive, like on guardianship alternatives to guardianship. So we do invite people to go to the Consolidated Planning Group YouTube channel and check that out. We also invite you to reach out to Leona Filis and her law firm directly for a free consultation if you want to go a little bit deeper. We want to be, conscious of everybody's time today. So I just want to remind everybody that you are going to get a copy of all of these slides and the contact information for Leona directly, how to reach out to her office, how to schedule. You can also, reach out for this publication. In our slides as well, you will also have a link to any upcoming webinars that we have. We even talked about child support today. So again, we go deep and wide on all of these issues. There's over 300 webinars on our YouTube channel that you can subscribe to for free, and we will definitely have that link to that out there and when we send those slides out. We offer free consultations as well. So if you've got questions that weren't answered, I did see somebody that said that they had a disability, couldn't really type their questions today. Do reach out to us. We do want to help you. We know in the course of an hour we can't always get to all of the questions that were there, but we did aim to answer as many as possible. This is a QR code. You can hover your camera over that when you guys get these slides, and it'll take you to our calendar where you can schedule your free personalized consultation. We also know that there are people that don't want to share all of their questions. They maybe feel nervous about that. I appreciate everybody putting their questions in the chat box because it did help others as well. One question that was asked in the chat box is, where could we get help if we needed some financial help with some legal stuff and things like that? There are legal aid organizations all across the state. They're called a variety of different things, but you can type in legal aid for special needs in your Google search bar, and it'll pull up your legal aid associations that may be near you, where they may offer some discounted programs for guardianship or special needs trust. There's also Disability Rights Texas. That's another place that you can check in with. One thing that I know is that if you live in Galveston County does guardianship for free. They have a big grant or something, and so you have to live there. You can't just go there and get it. But there are a few other counties across the state that have similar programs like Galveston. So those are things that are worth checking into. So if you're in here from Houston or Fort Bend County or Dallas or San Antonio, I am not aware of any of those programs of free guardianship out there in any of those places. But there is help for you if you are in a financial position where you absolutely can't afford these things. There are some services and some things that you can check into as a discount. It is worth it to check and see if you have a legal plan through work. And again, usually they'll give you a will for free and some of those documents, but usually, they'll offer a discount on the special needs trust. But that discount may be worth it to you. But what I would caution you is just make sure that you're working with a great attorney that is really nuanced in special needs, not just a generalist. So we are out of time and we went over horribly, Leona. I'm sorry to all of you for that. I hope you guys have a fabulous Saturday. If you're listening to this later on a podcast and you would like to get a copy of the slides, just email us at contact@cpgcares.net and we will be happy to send you the slides. And you guys should look to get the slides. I don't know if they're going out today or Monday, but you guys will get a copy of these slides on the recording. Thanks so much. And Leona, it was a pleasure partnering with you again. Take care, everyone.
Thank you.
Bye now.